Hello, hello, hello. Happy Tuesday, you guys. How are you? Wednesday? Today's Wednesday, not Tuesday. My bad. Whoops. Today it's Mike. Guess what day it is? Hump day. Hi, you guys. How is everybody? It's so good to see you. It's been a minute. I've been dealing with some real life stuff. You know how it is. Adulthood is the worst hood. Can't stand it. Don't want to be here, but am here. So here we are. Well, Mary Beth, thank you. I'm glad you're here. ATS sent you a recommendation and you got your first live. Well, I hope you enjoy it here. We're glad to have you. And Amber sent you too, Zoe. Well, thank you guys. I'm so glad everybody is here. All right. So I want to do something a little bit. I want to try something. Okay. So, what I'd like to do tonight is have a little chat with you guys, talk about ATS raid, woohoo! Is to have a little chat with you guys, right? Talk about what we're going to talk about, and then I'm going to be watching the chat and starring questions and comments and stuff, and we'll talk about it. You know, after I talk about what you know. You guys came to listen to, right? Because people on the replay, sometimes they don't understand, or have patience for the interacting with chat, but I do like to interact with the chat. So what I'm going to do is talk about what I came to talk about, right? For those people on the replay who just want to hear that. And then I'm going to talk about all the other things, right? Chit chat with you guys and answer questions and just, hang out. All right. Sound like a plan? I hope so. Okay. Now, we have been a little bit behind on Sarah Boone and things that have happened. And so I want to get to that because there's been some filings. And the first thing that I want to show you is Sarah Boone's jail report. And this comes from at the end of August, right? And I mean, it's nothing like super duper, like, she's not, really doing anything. But there's a couple things in here that I think are just interesting. Okay. So we're going to start here. Okay. This is pretty, humdrum. She got her USBs, she got her hard drive, her extension cord, her laptop, blah, 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 blah. All right. But over here on 8/26/2024, there was this. On 8/20, what is this? Is weird. I guess it means at. Let me make it bigger so I can see a little better. At 8:25 or on 8:26 hours, this is written very poorly, by the way. I heard loud yelling from the hallway. Upon further investigating, I'm sure, I realized it was coming from the briefing room. The briefing room was occupied by inmate Boone, Sarah, and Owens, James. Due to the loud disturbance, I entered the room and informed inmate Boone and Owens that they are causing a disturbance. Owens informed me that everything was good, that they had a little disagreement. After inmate Boone interview meeting, I spoke to her about retrieving a grievance form. Inmate Boone informed me that she did not need a grievance form. So trouble in paradise. Okay, I want you guys to understand that on 8/26, he wasn't her attorney yet. Like, it wasn't official. He was visiting her in that capacity, and but they hadn't agreed as of yet. So not much after this, just other than on August 30th at approximately 11:58 hours, inmate Boone completed her interview and viewing of physical evidence. I conducted and strip search at the conclusion of the interview and escorted Boone back to her unit. It seems that Boone might be back to eating again. Yeah. Let's see. On 8/27, due to standard operation procedures, ACA accreditation, our monthly shakedown was conducted. Inmate Boone was afforded the opportunity to utilize the laptop at approximately 21:26 hours, to which she refused. And these will be likely the last of the, oh, well, now this is interesting. Huh. Let me see this. She's still getting the drives and the laptop, even though, she has her attorney. Interesting. Guess they're not going to take it away from her because, nobody wants to hear Sarah Boone complain. So there's that. Okay. So there's that one. And we read that. Now, hang on a second. I want to look at this really quick. Oh yeah, this is where he just decided that he was going to claim her as his, what's this? Oops, sorry, wrong thing, you guys. My bad. Okay, this is what I really wanted to talk to you guys about. So, back before Sarah got this attorney, right? I think it's this one. Let me see. No, not this one. Back before Sarah's, when Sarah was still pro se, right before she and Mr. Owens sat down and decided that he was going to take her on as a client, and she was going to allow him to represent her. However, they worked it out. I guess in an effort to cover her bases, because she wasn't sure how this was going to work. All right. Or I suppose potentially it could be that that she is doing a little bit of work on her own, only because Mr. Owens said very, let's see, what does this say? Oh, I can't read it to the stamp. Dadgummit. Anyway, Mr. Owens was very, ominous and said, Sarah owes me, which I don't really know how that's going to work out too good for you, bro, because at the end of the day, Sarah has been, has filed indigent. It's been accepted that she's indigent, and she's been in jail ongoing for years. I don't know where this income, how she's going to pay you back, unless you guys have worked something else out where you're going to sell her, handle the rights to her story. I don't know. But if I were you and Sarah was my client, I probably wouldn't have gone on the news and said, Sarah owes me, because I just have my good enough diploma. Okay. So I didn't get further education, but I understand how money works. And as Stevie Wonder once said, nothing from nothing leaves nothing. You got to have something. And she ain't got nothing. So I don't know how that's going to work. Okay. Anywho, so Sarah has filed her objections. Now, remember, she met with the state, okay? And they showed her the physical evidence. And these are the things in which Sarah has said, I object, and doesn't feel that they should be admitted into evidence. So let's go through this, all right? Comes now the defendant, Sarah Boone. Okay, let's start at the very beginning, because this would be better. Motion to object by the defendant to state's digital evidence, USB jump drive. All right, let me do this all the way correct. Comes now the defendant, Sarah Boone, by way of pro se, respectfully requests from this honorable court that my motion be heard as to my reasons why I am objecting to the state's evidence against me and to exclude or limit the following particular items attempting to be admitted into my criminal case by the state. Objections are for digital content specifically and only located on the USB jump drive titled as, then it's the case number, Digital Discovery Compilation, which was submitted to defendant on August 9th, 2024. So these are her objections to that, all right? Objections by defendant are as follows. A, suitcase videos, 3 items. These files were obtained from my personal cell phone. There are no videos located in this folder on jump drive. This is the first image is a photograph of the suitcase. This is interesting. She has this listed as audio for 2 minutes and 3 seconds and then 22 seconds. Not videos. Interesting. There are no videos. So apparently you can hear the audio of what's going on in the video, but you cannot see the video. Okay. Lack of authenticity. There is no one to testify that the picture and audio are the same as the scene was at the time the audio was recorded and photograph taken. The prosecution fails to establish authenticity in any of these 3 items submitted. And then these are her state statutes that she sought, the statutes and supporting case law that she's citing. B, potential for unfair prejudice. I believe that the singular reason to utilize this audio is for the state to heavily prejudice the jury against me based on my statements in the audio to Jorge Torres. The prosecution's evidence is more prejudice than probative. And then she cites this. And she says this is a violation of Fourth Amendment rights, unlawful search and seizure. This audio was obtained by an unlawful search and seizure of my personal cell phone, and the defense moves to exclude any under my Fourth Amendment right. And then the body cams, death investigation. I think these are the videos we've watched. Again, she cites lack of authenticity. All of the body cam videos obtained from uniformed officers on the date of incident are time-stamped and documented incorrectly during the entire use while at the crime scene. It's a violation of best evidence rule. The state fails to provide the best version of this evidence under the best evidence rule. The state has not provided true and accurate video evidence, and the defense moves to exclude these body cam videos. All right. She also says a violation of Miranda rights. The body cam videos recorded me making statements and providing information prior to me being given any Miranda warning. These are illegal interrogations and a violation of my Fifth Amendment rights and should be excluded under the exclusionary rule. And then she's got another thing she wants thrown out. The defendant's interview, 1 item. Lack of authenticity. This interrogation video has no timestamp throughout its entirety of 2 hours, 6 minutes, and 3 seconds. She cited the best rule. Again, best evidence rule. And now she says the defendant requests that the due date be extended to submit objections based upon the defendant, 1, is unable to utilize her 6th constitutional amendment right to counsel, has never been pro se before, is not an attorney or an officer of the legal system, lacks requisite professional competency, experience, expertise in the legal field, is currently incarcerated, has extremely limited and restricted sources to conduct extensive legal research to further support objections, no internet, does not have full-time use and access to a laptop, does not have full-time use and access to tablet, does not have access to privacy, temporary for in-depth review of discovery, has limited access to defense team investigator to collaborate and complete greater work product. These objections were done as expeditiously as possible based on my current circumstances. The process for a pro se defendant requires much more time, essentially while incarcerated, than that of an unrestricted, well-educated, resourceful attorney who is fully capable and has all of the aforementioned availabilities. Also, I reserve my reasoning or reasonings for my objections for in-court oral arguments. Wherefore, the defendant, Sarah Boone, by way of pro se, respectfully moves this honorable court in conclusion to hear my reasons why I'm objecting to the state's evidence against me and to exclude or limit the included particular items attempting to be admitted into my criminal case by the state. And then she has signed it, all of the things. Now, oh, well, hey, Cement Shoes, thank you for becoming a YouTube member, although you've been a member for 31 months. I think Cement might have been one of my very first members. Thank you so much. I appreciate that. Thank you for your support for 31 months. That's a lot. That's a long time to put up with the likes of one Jen Liu. That is for sure. Now, so here's what I'm thinking. First of all, it has to be entered on the record because I think what Sarah was doing was, covering her bases here. And she wasn't really sure if Mr. Owens was going to show up or if they could get to an agreement or what have you. And so she went ahead and filed these objections. Now, I'm a little confused about her description of these videos and these pictures, because it's, obviously she's aware that they're, it's not complete. It's, how do I put this? She's aware that people are watching, right? So she's not going to want to put all of the things out there because she knows this is part of the public record. But from my memory of the information against her, which is what, how they ended up charging her and the warrant and all the things, right? Okay. I believe what she's referencing are the 2 suitcase videos. This photograph, I'm not exactly sure what she's talking about, but we know, because we've seen them, they're on the internet. We know that there is both video and audio of, on that phone of what occurred in that apartment while George was begging for her to let him out of that suitcase and that he could not breathe. Can we play tag? Anyway, keeping you in my thoughts. Thanks for putting up with my crazy. You did best. Well, thank you, Mayla's mom, for being here for 6 months. I appreciate that. So anyway, I appreciate that, babe. But yeah, of course she wants the videos thrown out. Of course she does, which I have to say was not... I have to say that was on her part. Of course, that makes the most sense to get that thrown out. The body cam, she's not going to get that thrown out because she's not under arrest. She's not being detained. The only reason the officers are there is essentially to secure the scene because there's been a death and it's their job and they have a report to fill out, right? It's the people that were investigating the actual death are the detectives, not the cops, the patrol officers. Okay. You don't have to speak if you don't want to, but they don't have to Mirandize you. And that's just the way that it is. I mean, it's not, she called 911 for Pete's sake, right? To report what happened. And in that 911 call, she said all kinds of stuff. She's not trying to have that. Not admitted. Although that's, I'm sure that's on there. And, so that's one that I would want to have thrown out for sure. I mean, you're out here, you're calling 911. You sort of sound freaked out, but not freaked out about what happened, more freaked out for yourself. And then you spend almost the entirety of the 911 call trying to act like you're doing CPR when you're not doing CPR because you wouldn't be talking. So, it is what it is. I don't think that, let's say that James Owens wasn't representing her, right? And and she was still pro se. I of course would love to hear her oral arguments on the matter as to why she thinks these items should be limited or not admitted at all. But I have a feeling that whatever her arguments aren't going to be salient arguments and probably not based in law. And so I don't think it would be very effective, although I applaud her for knowing that these are the items that are probably the most damaging to her, right? Those suitcase videos are, in my opinion anyway. And I say that because I don't know what George's autopsy reveals, so the part about that in the information or the probable cause affidavit is very limited. And so that is one thing that I'm quite interested in hearing about are the results of his autopsy. But I think that the suitcase videos are the most damning. I don't think that other than a few jokes here and there, like when she can't stand it anymore. She's so thirsty. She drinks directly out of the faucet outside. I mean, hops right over that little tiny shrub. It's not very big, but it's one of those shrubs that the leaves are prickly. And she just didn't even give her rat's fat kneecap. She's just out there and she's like, I'm done. I have to have a drink. I'm thirsty. I don't care. I'll drink from the water faucet. I don't care. I mean, there's some jokes in there, but nothing that's really in that body cam footage is particularly damning. Now, I noticed that there is something she did not mention, and that is the interview that took place in the cops or the detectives' vehicles before the interrogation that we have video. This is just audio, and she didn't mention that. And in that audio, she does say some things that are interesting to me if she plans on, through her attorney, using this battered spouse defense. Because one of the things that I noticed when I was doing the research to understand what is I mean, obviously I know what a battered spouse is, but how that applies to the law. Okay. And things that they're looking for when, like, a forensic psychologist goes in and interviews a person who's potentially trying to use the battered spouse defense. And there's just one thing that is really missing. And, but it's, I think it's interesting, is that one of the things they cited is that the victim of being a battered spouse will take the blame on themselves and really refer to their abuser as without fault. And Sarah does not do that. And she, that's interesting to me. That, it's just one of the things that I noticed, right? So she's not going to get that interrogation video out because I am unsure that there is a version of her interrogation video that exists that is timestamped. If that's what she is insisting on. I don't think that a timestamp is going to be the thing that gets the interrogation video thrown out. So yeah. And yes, excellent point, Skylab. Everybody, please turn your eyes, if you will, to the screen right now. Sarah wants all of you to know that this indeed is legal mail, as she has labeled it such, not once, not twice, but 3 times. Just in case anybody was confused, that mail is legal. Okay? So, all right. So, AKA the cat lady asks, was the brother that Sarah got to beat George the one who was arrested, Pharrell? Okay. I did some looking up of Pharrell. And yes, of course, there is the incident or the charges, the most serious charge, which is murder. And he murdered allegedly, he stands accused of murdering his wife or girlfriend. But there is an incident that is listed on Pharrell in Orange County. And it seems as if what happened was the police were called because Pharrell was threatening his family with a knife. And there is mention of a Jorge Torres. Here's the problem. There are 2 Jorge Torreses, obviously. There would be Jorge Torres Sr. and there would be Jorge Torres Jr. And it isn't specific in that file. So, in the information. So I hesitate to speak on it further and say yes or no, because the truth of the matter is I don't know. I don't know. I can't answer that question. And so I don't know the answer to that question. And the truth of the matter is, although Mr. Owens decided that it would be a good idea to make this comment that he made in his initial interview right after court, none of the things that he says would be admissible. Pharrell, what Pharrell's charges, I'm not sure about that, aka the cat lady. I'll have to look. But that's the only thing I found with Pharrell. So if that was, I can't remember, because the truth of the matter is I didn't like what Mr. Owens did in that situation. I think what he did was he said what he said because he knows the public interest in this case, and that people would go and look, right? But the truth of the matter is one thing doesn't have anything to do with the other, right? It's not, George is not on trial. Sarah is. Pharrell is not on trial in this case. Sarah is. So, I don't know the ins and outs of it. But at the end of the day, what is going to happen is it's that kind of stuff is not going to be able to be admissible. Now, there would be the only thing that would be really admissible as far as George goes. If Sarah's using the battered spouse defense, they're going to pull up the incidents of domestic violence between the two of them. And to be fair, it doesn't really make either one of them look all that great. So if there is, what I'm saying is, if there is an incident between George and his brother, I can't find it. It's not like, I suppose I could try harder to look and get back to you guys about that. But at this point, I don't know. That's the answer. I don't know. So really quickly, let me say this. Thank you, Lisa, for gifting a membership. If you got one, if you're the one that got it, please thank Lisa. Also, Neat Noodle gifted a membership. If you got one from Neat Noodle, please thank her. I appreciate that from both of you. Very, very generous. I appreciate that. So let me see. The next thing I wanted to show you guys, give me just 1 second. Let me close this because I don't want to get confused. Let me see what this is. This is quite interesting. All right. This is another filing by Mr. Owens, which I am very confused about. And because it says indigent for costs affidavit of attorney's fees. Let me make this a little bit bigger. I, Sarah Boone, am represented by James Owens Esquire in the above entitled action. The attorney has agreed to accept the case pro bono. No other compensation, things of value, or funds have been paid or are anticipated to be paid in the future to the attorney in this case from any other person or source. Under penalty of perjury, I declare that I have read the foregoing indigent for costs affidavit of attorney's fees, and the facts stated in it are true. So now, he's pro bono, which means that he's not collecting anything. So now he doesn't owe. Now the whole situation is she doesn't owe him. So there you go. Now it's in writing. AKA the cat lady, thank you for the super sticker. Do you know how to access the motions from Padilla? I do. I'll look into that for you guys. Is that what you want? I mean, I can. Here's the, is there something specific you want me to, specific that you want me to look up? AKA the cat lady, from those motions. If they're there, if they're for the public, I can look them up. All right. So that's that one. Let me see. What's this? All right. So now this is the stuff that the state has shared with Mr. Owens. AKA the cat lady says Padilla didn't go with battered spouse, so I'm curious what he was going with. I'll look and see what I can surmise from the things that were filed. However, what I will say is this: one of the things or possible defenses that Mr. Owens mentioned was battered spouse. Okay, and he specifically said that he wanted to utilize a expert witness who'd already evaluated Sarah Boone, and that is the same expert witness that Padilla used. And so I'm curious about if that was what Mr. Padilla was going for or what, because the thing is, you do have to, if Padilla intended to use the battered spouse defense, you have to give notice. And you have to do it 30 days before the trial. So we are on 9/11/2024. Now, I've not gone through all the motions, and I don't know if Owens has filed that as of yet. But if he were going to do it, he has until it would have had to have been done the 7th of September. Okay, so I don't know that I'll go back and look to see if Padilla gave that motion. Now, I know that he filed a motion to withdraw, and it might have been like right before that deadline would have been, or right at the time of the deadline. And so it would be difficult to know if that is what if that's a defense he intended to use, because I think that he filed a motion to withdraw right around the same time, like that would have been required of him to disclose. So, but I'll go back and look. I will make sure that I check it. What's up, MK Lynn? How you doing? All right, so there's that one. Oh, wait. I didn't even tell you guys about it. Holy moly. Hold on a sec. Let me close this. Let me show you guys what the state has turned over. That's what I was doing. Sorry. It's weird when you don't go live for a while, you forget, like you're rusty, and I feel very rusty for no reason. Let's see. I think this is it right here. Yeah. All right. So let me share this. All right. Here we go. So far, this is what's been shared. This was filed on 9/6/2024. Comes now to the state of Florida by and through the undersigned assistant state attorney, and gives notice that copies of the below listed digital evidence have been disclosed to Mr. Owens, physically picked up on September 5th, 2024. 911 CAD, calls for service, domestic violence history, incident reports, interviews, OCFD run sheet, case synopsis, property forms, Publix video surveillance, search warrant, social media, 2 videos from S. Boone's cell phone, CSC form, Detective Copsel investigative report, Jamro written sworn statement, partial extraction, report call logs, waivers and affidavit form by Sarah Boone, a CD with the 911 call, DVD with interviews, DVD with videos from Sarah Boone's cell phone, public surveillance, CSI. These are all the discs. And then digital forensic. Holy moly. 32. What's BG stand for, you guys? Big ass files, a bunch. Forensic extraction for the cell phones. So there you go. So now they have all of that. All right. So that's going to be interesting for them to see how he's going to handle that. All right. Now, let's see this one. Oh, and here we go. The question is and going to be answered shortly. Here we are. All right. This is going to be Sarah's defense. And right before the deadline, 9/6/2024 at 10:22:44 a.m. comes now the defendant by and through the undersigned attorney under Rule 3.201, Battered Spouse Syndrome Defense of the Florida Rules of Criminal Procedure, gives notice of intent to rely on the defense of battered spouse syndrome and states. 1. At the time of the alleged offense, the defendant was suffering from battered woman syndrome as a result of the physical and psychological abuse the defendant sustained at the hands of the alleged victim, Jorge Torres. Dr. Julie Harper will be a Category A witness for the defense in establishing this condition on behalf of the defendant. 3. Dr. Julie Harper, forensic psychologist, and these are all her things. That's who they're going to be. So there you guys have it. Now, did I say bodyguard footage? I probably meant body cam. Sorry, I probably misspoke. My bad, Sally. So there you have it. She's going to use the battered spouse defense. I just don't. I'm really curious what this psychologist, because she's a forensic psychologist, so this is going to be quite interesting. Quite interesting, the results, because she's probably going to give her all of the tests, and so interesting, huh? There you have it, you guys. Now we know what Sarah Boone's defense is. All right, let's see what else we have over here. Oh, this was made a little, okay, so Mr. Cacciatore, who's been really handling this case thus far. Okay, okay, Lisa, we're getting there, babe. We're getting there. We're getting there. I'm going through them as they are submitted. I'm going chronologically. We'll get there, I promise. Okay, so let's see. Let me see this. All right, so this is an interesting little thing here. It is from Mr. Cacciatore, who's really been the one that's been handling this case for the state of Florida. And he just wanted to make notice of unavailability. But the dates are interesting because he won't be available for anything between on December 16th, 24 through and including December 20th of 2024. Now, I was over in the Lawyer You Know's chat, and I was listening to this particular part because, of course, I'm not an attorney, and so I was quite interested in what the Lawyer You Know's thoughts were on this specific thing. And he explained it quite easily, which it could be a couple of things. One, it could be that he had his law clerk just file a blanket notice of unavailability to all of the cases that he is currently handling, rather than trying to go through each one and figuring out, will I be there? Will I not be there? Yada, 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 whatever, right? Or, and this was in chat, and I thought this was actually quite smart. And I can't remember who commented it, but whoever commented it was thinking very smartly. The dates. Okay, so the trial is intended to start October 7th. Now, that is when jury selection starts. And I don't know how long it's going to take them to seat a jury. I mean, there's only so many, there's I mean, it can be a lengthy process, but let's say that it takes a couple of days. Okay. That means that opening statements begin on the 9th, right? All right. So, and the trial was scheduled for 3 weeks. So that puts the end of the trial, what? Roughly 21st, somewhere in there, maybe the last week of October, right? If it lasts the entire 3 weeks. Now that she has a lawyer, I don't know that, but it might. All right, it's scheduled. There's that enough time allotted. Okay, so let's say the trial is done on, and I'm just picking a random date. I'm not looking at a calendar. Let's say they finish everything up and it's set for deliberation on the 25th. Okay, and the jury takes 2 days to deliberate, and they come back on the 27th, and they find Sarah guilty. So then I'm sure that that the defense is going to request a pre-sentencing investigation. Okay, and I don't know if you guys were paying attention or watched Wade Wilson's trial, but when they came back with guilty, and then they recommended the death penalty, the jury did. They did ask for a pre-sentencing investigation because it's ultimately up to the judge, right? And the judge said, okay, well, and also with Ashley Benefield too, the judge that pre-sentencing investigations are running about 6 weeks. So I'm wondering if that is maybe why it was included in this case, because he might not be available for sentencing should she be found guilty. So those are the couple of reasons. All right, now let's see what else we have on the filings. Okay, the defendant's reciprocal discovery. Basically, this is the CV. Let me see if I can remember how to say this. The curriculum vitae. This just is about Dr. Harper and all the, why she's an expert, all of her credentials, all of those things. Then there's a motion for additional discovery. And let's see. So what he's asking for is under 3.220F, additional discovery on a showing of materiality. The court may require such other discovery to the parties as justice may require. Specifically, the defense requests the Office of the State Attorney to provide the standardized Miranda rights written policy form and card of the Orange County Sheriff's Office relating to the Miranda rights form utilized and read directly to any suspect before any interrogation. Okay, so now he's going through and trying to see if the interrogation is legal, because was Sarah read her rights? Were they read to her correctly? Did she know what she was getting into? Blah, 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 yada, 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 whatever. Look, here's the deal. I found that interrogation to be quite painful because I felt like they should have let her talk just a little bit. I understood that they were irritated that, she was kind of going in circles and, she was insistent upon no malicious and all the things, right? But I do think that having her say a little bit more would have been helpful to understanding, to getting a glimpse into her state of mind, as it were. Okay, so now remember when before the thank you, Neat Noodle. so I'm almost positive they did, but I will look into it. Okay, so now remember before the hearing that happened on the 3rd, one of the filings that Mr. Owens did on behalf of Sarah Boone was to make another motion for or make a request for a statement of particulars. Okay. And this is the state's response to that statement of particulars. All right. Well, let's see. Before we do that, let's do this. Let me go over here to the YouTubes since we're asking about it, and it's been a hot minute since I have listened to that interrogation video. Let's listen. Let's go. Let's check it out. So let me look it up really quick. Let's see if they read her rights. All right. Give me a second because let me go to this one. For some reason, this is interesting to me. There are, hang on. I'm going to use the one from Law and Crime because the one from Court TV is shorter. And obviously something has been, not, has been edited out of that. And obviously we need to hear the things. So we need to have it not edited out, right? All right. So let's play this. All right.
Just let us know if at any time you need more, okay? I'm gonna have you sit in the green chair that doesn't move. Appreciate you coming in.
Yes, ma'am. And I want to ask you about these whenever we have a moment.
Sure. So obviously, he received his autopsy. So I'm going to read you your rights again because we have to talk about that. And since I'm talking about the incident, we just have to do it, just like we did yesterday.
Protocol?
Just like we did yesterday. Remember I read you the rights? Your rights? Yeah. So it's the exact same thing, but since I'm asking you follow-up questions, I need to read them to you, okay?
Sure.
All right. So you have the right to remain silent. Anything you say may be used against you in court. You have the right to talk to a lawyer before and during questioning without charge. If you cannot afford a lawyer and want one can be provided for you before questioning without charge. Has anyone threatened you or promised you anything to get you to talk to me?
No.
And do you understand what I just read you?
Yes.
Perfect. Okay. So this morning we went to his autopsy, and we were informed of some injuries that he has by the doctor. So so he's got scratch marks to his back.
I know what that's from.
Okay. And
Fantastic. Thank you, Sarah. What do you guys think? Wait, what is curious? Christine says. I feel like there's more to the Miranda rights. So let's look this up. Let's look it up. Let's see. just listen. I know sometimes when you look up stuff, they want to, if you look stuff up that is sponsored by an attorney, the first thing they do is ask you if you need an attorney. I don't need an attorney. Just a second though. I want to see something here. I would like to also know I want to see exactly what the Miranda rights are. Well, I will learn. I did learn this. One firm. Okay, so this is when does the Miranda warning not apply in Florida? The Miranda warning is only in effect during custodial interrogation. Huh. Interesting. Not been taken into custody, the person, or this is another thing. Okay. Some exceptions to Miranda rights are the person has not been arrested yet or taken into custody. The person is being charged with loitering. The person has been stopped for a suspected traffic violation, public safety exception, and terrorism. They don't have to read you, but I'm very curious about this. Hold on, let me see what this is. Here we go. See, I don't know. I think that the one that they left off is if you decide to answer questions now without an attorney present, you will still have the right to stop answering at any time until you talk with an attorney. I'm kind of curious about that, you guys. I wonder if that's going to be a problem with her. I mean, let me look and see if I can look at the transcript here and see if they go on to read her more in this interrogation video, because I don't know. That might be quite a sticky situation. Yeah, but here's the thing. And then asked her, remember yesterday we went over this. Okay. Yesterday is not today. And yesterday she's not. Yesterday she was the yesterday that you're referring to, she was not detained. She was free to leave, and she was in a police car. I'm not sure about this. I'm not sure. This is very different. And when I looked at Florida Miranda rights card, it does, but this is Miami, Florida, and I don't know. I don't know what the answer is to that. There's a reason that I agree. I agree that it might be a stretch and it might be a grasp. However, I'm not sure. I'm not an attorney. So I'm just telling you what they're likely going to argue. There's a reason that he's asking for that. Okay. And there's a reason that he's asking for that. And I don't know I don't know if I don't know, because I'm not an attorney, and all I can see is that he is asking for their policy. And so if what they did falls in line with the policy of Orange County, then the interrogation is good and everything she said can be used. Now, if they didn't, right, even if it's a grasp, okay, then what he would do would be to obviously argue that in court. Well, obviously the state is going to argue that back too, and it will be up to the judge who has the better argument. I think that I don't think this is enough to get her interrogation thrown out. But I'm just curious about that because, I mean, it is something that he brought up. And, you know, I would like to know why he brought that up. And I would, you know, I would like to know. All right. So let's move on from that document to what we were going to talk about, which is, oh dear, what happened? My comments just totally went away. Oh, they're back. Okay. All right. Well, if the lawyer, you know, I trust him, and if he says that it was fine, then it's fine. I'm just okay. I don't think it's going to get thrown out. I'm just talking about what he's trying to do. These are things, you know, these are things that the defense is trying to come up with. And we already know the state's case, right? So now we're getting a little into what the defense is trying to do. So that's why, you know, I don't know if it's going to work or not. I don't think it will, but that, you know. All right. So here is the response from the state to the motion for the statement of particulars. All right, here we go. Let's see. They wanted to point out that receiving a statement of particulars is not a legal right, but rather an act of judicial discretion. 3, a statement of particulars is not necessary in this case for the following reasons. There's no variance in the information and discovery as to the date, time, and place of the offenses. There's no variance in the information and the discovery as to the name of the victim. The information filed tracks the statutory language in 782.042, putting the defendant on notice of the law she has alleged to have violated. Wherefore, for the grounds above cited, the state of Florida respectfully moves this honorable court to deny the defendant's motion for statement of particulars. So they want it to be denied. What the heck? Hold on. It's making me freaking log in again. Come on, Orange County. You know me. I've only searched this site like 11 billion times. All right. All right. Let's see. Now, let me close this one and this one. And stop sharing. Let's see what else is on the docket. What else we got here? Let's read their motion to strike. And this pertains to the battered spouse defense. So let me see. Okay. Let me add this to the screen. Let's see what the state has to say in response. All right, I'll make this a little bit bigger. All right. Let's see. All right. Florida Rule of Criminal Procedure 3.201B requires the defendant to include, quote, a statement of particulars showing the nature of the defense the defendant expects to prove. 3, the defendant's notice does not include any particular facts, which if produced at trial would allow for Dr. Julie Harper to opine that the defendant suffered from battered spouse syndrome. Therefore, the defendant's notice is legally insufficient and the court should strike the notice. Furthermore, the defendant only lists Dr. Julie Harper as a witness to show the defendant suffered from battered spouse syndrome. An expert witness cannot be used as a conduit to introduce inadmissible hearsay evidence, such as the defendant offering the defendant's hearsay statements. Therefore, the defendant should be precluded from mentioning battered spouse syndrome in her opening statement, and Dr. Julie Harper should be precluded from testifying until the defendant testifies to underlying facts that would allow for her expert's testimony. See, now I wondered about this. The defendant has previously provided statements to law enforcement. Therein, she claimed she accidentally left the victim in the suitcase overnight. Battered spouse syndrome testimony is not admissible if her defense is that killing the victim was an accident. The defendant should be precluded from mentioning battered spouse syndrome in her opening statement, and Dr. Julie Harper should be precluded from testifying until the defendant has presented evidence of justifiable use of deadly force. Finally, the state requests the defendant be ordered to submit to an examination by an expert of the state's choosing. Yikes on bikes. He said no, which I am interested in that because to me, it seems, and I am not an attorney, but to me, it seems as if the battered spouse defense is almost a, what is the word I'm looking for? Help me. Affirmative defense, wherein she is saying that essentially it's self-defense. This person I'm a victim of and I suffer from, I'm a victim of domestic violence. I suffer from battered spouse syndrome, and I had no choice. It sounds to me like battered spouse syndrome as a defense is an affirmative defense. And if you're saying you did it, then how can you be also simultaneously, and when it happened at the time of your interrogation, saying it was an accident? Okay, Lisa, help. Okay, so Lisa says, Jen Lou, I got an answer from my brother on Miranda, and when they are required to read it to a suspect. Is your brother a Florida law enforcement? Ouch. I just banged my knee on the desk. That hurt. I can't wait to hear. Correct. The video mocking him negates an accident and self-defense. Now, what Sarah's contention is the death was an accident, not that she accidentally put him in the suitcase. It's that she forgot that which is preposterous because, again, the video shows differently, right? That she put him in there and she didn't zip it up all the way. So he should have been able to unzip it from the inside, except for the fact, Sarah, that the suitcase was flipped over. And so the lid of the suitcase, where it would open, I don't know how really what you call that, but the top of the suitcase where it zips together he was laying on it. So even if he were somehow to magically be able to unzip all of that, how would he have gotten out? All right. Well, what did he say? I appreciate you asking your, okay. So she asked, custody and interrogations. Miranda is the easiest way to understand it. Doesn't have to be physical custody. If somebody feels they aren't free to leave, they are in custody. Sounds like they were. Yeah, Tony, I banged my knee. It hurt. Wait, where's the other part? Oh, that they were in. Okay. Yeah. So I think that the Miranda is going to be fine. I don't think they're going to get it thrown out, but thank you for being here tonight, MK Lynn. Have a great night. Exactly. He never would have been able to get out. So but now she's switching it up and saying, oh no, he was an imminent threat and I wasn't thinking. And, because he abused me verbally and physically and emotionally, that my thinking was askew. And I don't know that she's going to be allowed to use it. I really don't. I think, okay, so Harlot says she'll probably say she was afraid to let him out of the suitcase, but didn't realize that he would die if she left him in there, in my opinion. I think that is what happened, except for being scared, maybe. Well, the problem is that that's not what she said. What she said was that she didn't zip it all the way so that George could get out. So if you're putting somebody in a suitcase because you're afraid of them, they're an imminent threat to you, you're afraid, and you're not thinking clearly, then why would you allow for there to be room for that person to escape the suitcase? See, she can't have it both ways. Okay, so Lisa says suspects have to be in custody and subject to questioning for Miranda to kick in. She was not in custody. She was free to leave until the video. Gotcha. Yes, and her saying, but the problem is that I fell asleep. So which is it, Sarah? Did you leave room for him to get out? Did you not? Did you think you were going to leave him in there and teach him a lesson and then you fell asleep? So, I mean, I don't know if that the judge they're going to have to argue this. Now, I will tell you that we don't have anything until the 26th. And that is excuse me. I'm sorry, you guys. That's the trial management conference. And so we're just going to have to wait. All right. Now, the next thing I wanted to show you guys, which I'm late on, and that is this interview that Mr. Owens gave to Court TV. And I have to say, whoa. They start out the interview with him with like a dramatic reading of her advertisement. And while the producer who's reading the advertisement does a good job, not to toot my own horn, but toot, toot. I think my reading of her advertisement was just like maybe a tiny bit better. I was more dramatic and uppity. You know, I tried to really harness what I thought would be Sarah's, you know, the essence of Sarah, as it were. All right, so let's get here to this interview. I'm not going to play I'm not going to play her reading of it, but if you guys want to, obviously you can go back and listen to the, like, rewind it, like, I don't know, the beginning of this or whatever, and it'll play that. And then the dramatic reading that I gave is on the channel if you want to compare and let me know who did it better. I'm totally teasing. Okay. All right, so let's listen to this. I have to take care of Nestor, so I'm gonna let this play for a little bit, but then I will be right back. Okay, please behave while you're here. Please don't make my mods mod. Here we go.
Take this case. Yes, an attorney in Florida. Joining me by phone, Sarah Boone's ninth attorney, James Owens. James, thanks so much for joining us tonight.
Thanks, Vinny, for having me.
Okay, the first question I know everyone's asking you, why? Why did you take this case, James?
Well, you know, I watch a lot of YouTube, and I watch a lot of court TV, and I've been following this case just like all the other true crime people do, and you know, kept watching it being delayed and the lawyers being switched, and then saw that the judge got fed up and ruled that she had forfeited her right to a court-appointed counsel. And so that's a rare event. You know, as lawyers, we know that, you know, everybody has a right to a lawyer, a court-appointed lawyer, if you can't afford one. So on a serious charge, a felony, in this case, it was a murder, for the judge to revoke that right was a serious decision on his part. I don't disagree. I respect the court's decision, but that left her facing a murder charge without a lawyer, which is unheard of, I think. And so, you know, I watched for a while, and then I saw the ad on your show, and I think that you had said something implying, hey, who's gonna take the case? What lawyer in Florida is gonna pick up the torch, so to speak? And I think you had somebody on, maybe it was a lawyer from the Northeast, and I think I remember that lawyer saying, man, if I was a license in Florida, I'd take the case, you know, under that scenario, because she really needs a lawyer. Everybody needs a lawyer. And so the ad came out, and I sat there and waited for 3 or 4 weeks. I can't remember now how long I waited, but I was thinking that a lawyer out of Orlando would pick up the case. Somebody would think, hey, this is not right. There's no way she's going to get a fair trial representing herself. It's unfair. But there's a gap in the system. The judge made a decision based on her conduct that she had forfeited a right to a lawyer. I believe that's where the private sector has got to step in. Somebody in the private sector in that situation, and it's rare, should step in. So like I say, I waited. Nobody responded in the local area. So I just happened to have a case down in Hillsborough County that I was going to down in Tampa. And so I knew I was scheduled for court down there. So about a week before that, I sent her a letter, and she had a third party contact me to, I guess, check me out to see if I was legitimate. And
Well, I think everyone's been
You know,
checking you out in the last couple of days, and everybody knows you are absolutely legitimate, James. I mean, you have quite a history.
I've been doing it a long time. So anyway, she reached out to me, and then a couple of days later, Sarah called me from the jail in Orange County in Orlando. And we talked for a little bit, and I explained to her that I was coming down that Wednesday, but I'd come down early and spend Tuesday talking to her, and she agreed. So I drove down Monday after work. Tuesday morning,
can you describe that meeting without, I know attorney-client communications is off limits, but how would you describe that meeting to someone? Like, was it different than meeting other clients for the first time?
The first meeting?
Yeah.
No, it was a 4-hour meeting. I usually don't meet with clients in the jail for that long. So I gave her a chance to talk and just listened. For a long time, she had a lot to say. Obviously, she's been in jail for 4 years. And, we had a good meeting. Just, again, I think she has trust issues because she felt like she did have some good lawyers that were on her case and just withdrew because they would get in some arguments about issues, I guess. And so she said they wouldn't even tell her anything at the jail, but the next thing you know, she would, be sent to court, and the lawyer had filed a motion to withdraw. So she didn't, trust the lawyers because she didn't know who to trust. She'd been with so many. So a lot of it was just trying to build trust with her. After she talked a little bit, I told her a little bit about myself. So really feeling each other out and trying to build some kind of rapport was the first meeting, which was about 4 hours. But I think early on in the case, I was able to persuade her that I knew what I was talking about because I was prepared. When I got there, I was prepared, and I played part of that 4 hours. I played the prosecutor, and I pulled out the jury instructions, and I made an argument as a prosecutor would make to a jury, and I had her sit there and listen to it. And I think that was effective. I don't think she had anybody ever do that to her and explain it to her that way of how it would play out in court. And that got her attention. And, initially I was going down there. And let me tell you, my initial thought going down there was this. She didn't have a lawyer. And once that happens, once they're pro se, then as well as I do that all these cases are up for negotiation. Plea agreements are pretty much on the table at any time, and judges recommend, the courts recommend, you try to work cases out. The vast majority of cases get worked out with pleas. So, I talked to her about that, and that was my intent. I'd called the prosecutor and told him I was coming down there to speak with her ahead of time, and he wanted me to file some kind of a notice of appearance, and I didn't want to do that. I wasn't ready to take on the case. So I got her to sign a document essentially saying, hey, I don't want to negotiate directly with you, state attorney. I would like for James Owens to work, just to talk to you.
Okay. Now, it is entirely possible that he explained this scenario to her as him being the prosecutor in such a way that it finally clicked. But it's also equally as possible, and probably, in my opinion anyway, more probable, that Sarah basically knew she was SOL, and that she was desperate. And so she said, that's the rapport that was built. That's the quote unquote trust that she says that she built, or he says that they had for each other. No, JoJo, she has not fired the attorney. This is just, it took a while. It took a couple of visits for him to go to visit with her before both of them agreed that he was going to be her attorney, that he would represent her. And I think that back to what I was saying is I think that Sarah was desperate, and I think that she recognized that she was at a significant disadvantage if she continued to do pro se. And no, you're all right, JoJo. It's okay. You just got here. It's no big deal. I mean, it does kind of sound a little bit like maybe, but no. Anyway, I think that, she recognized that. And I think she thought, I mean, what's the worst that can happen? So I think that he started out just agreeing to go and negotiate with the state, right? And I don't think that it would have mattered what the state offered her as far as a plea deal. I don't think Sarah would have accepted anything less than time served. And I don't think the state was going to offer her that. And so Sarah's like, well, okay, then let's go to trial. I'm very, very curious and interested in this next hearing that's coming on the 26th. I don't know if that will, if that's when they will discuss this battered spouse defense, or if there will be a hearing between now and then, because it seems like that's something that's really cutting it very, very close to the time of the trial. And so I hope that Mr. James Owens over here has not put all of his eggs in this one basket and thought, oh, I'm sure this is going to be fine. And I hope he has another defense strategy worked out to go with in case the judge says, you know what, the state's arguments are better than the defense's arguments, and we're not going to allow the battered spouse defense. But the other thing that I'm really, really curious, how it's going to go as far as when it comes time, because the judge will ask her if she wants to testify. And I just feel like Sarah, through all the letters that she has written, one of the things, there's a few things, but this one is something that stands out as important, in my opinion anyway, that she's consistently mentions, and that is the telling of her story. And the way that she writes it, the words that she uses, it seems to me that what she's trying to say is that she wants to be the one to tell the story. And the only, so if it's going to be her telling her story, right, then the only way for her to do that is for her to get up on the stand. And I think that that is, under the very best circumstances, a very, very dicey move. It hardly ever works out in favor of the defendant. Usually it makes it worse. Usually because it doesn't matter how well your attorney preps you to testify in a criminal trial for you to take the stand in your own defense. They can't prepare you for the questions that the prosecutor is going to ask. And the way that that's the thing about a really good prosecutor, is able to, they might have in mind, obviously they base their questions on the testimony that's given on direct. That's how they base their cross. Both sides do it. but the best attorneys are the ones that are able to also react quickly to a response to a question that they've asked, and ask you a question in another way that actually almost catches you in a lie, and it makes you look horrible in front of the jury. Those are the best attorneys. Camille Vasquez was really good at it with Amber Heard. She got her all kinds of, jammed up. So that's why you don't want to take the stand in your own defense, and you're not required to. And what's more, the judge will instruct the jury that they're not to make any have an opinion on, and they're not to render their verdict based on whether you testified or not. So because you have the right not to. All right, so let's see what else he has to say, or hear what else he has to say.
And so she signed that, and I did, for a couple of days, talk to the prosecutor. I was trying to resolve it.
Right. And
I felt like the judge is fixing to have a trial, a 3-week trial with a pro se defendant. Prosecutor is fixing to have a trial with a 3-week trial with a pro se defendant. It was not going to be fair. And I felt like they might be in a posture to try to negotiate something that would be doable. So that was my first intent, was not to handle the case, not to try the case. If we got something worked out, then I would file a notice of appearance, and we'd set it for a court date to resolve it.
that didn't happen,
was my
though.
first. No, it didn't. And, I left that 4-hour meeting. I went to Tampa the next day, had court, and then turns out the investigator that had been assigned to the pro se litigant, Sarah Boone, he was meeting with her that evening at 7. So I asked if I could just join. So I came back over and spent about an hour and a half with her and Billy Lane, the investigator. And we talked some more, and I was convinced that there was going to be no plea bargaining. So I told her I was not representing her and I was leaving, and I emailed the prosecutor or called the prosecutor and said, look, we've reached an impasse. There's no agreement, and I'm not going to be representing her. And I went home. And I want to say a couple of days later, Sarah called me and we talked some more. And I told her Vinny,
So, but at this point, she's now reaching out to you because she wants James Owens to represent her.
Well, we did connect. And I think she was overwhelmed being her own lawyer. She was stressed out.
Yeah.
She had all this discovery that she was trying to go over. She didn't know what she was doing. She didn't know the rules of procedure, rules of evidence. And she had told the judge, I think they'd had a couple of hearings on some issues, and she said, Judge, this is not fair. I don't know what I'm doing. And the judge kept saying, well, I'm sorry, ma'am, but this is your position. So I think she was just thankful that I came down to see her. We had, some good meetings. So I think she really needed some help. So I think that was partly to do with it, but there were still some issues because I think she was let down because I said I wasn't going to represent her.
Right.
So we got off the phone. I still said I wasn't committed to it, but I was thinking about it. But as you know, second-degree murder trial, and the judge had set a firm date for October the 7th, which is really difficult to do. I mean, you pretty much have to shut down your practice for 30 days or 6 weeks.
Absolutely.
And
Okay, so my initial impression of this gentleman when he decided to take on Sarah's case was, on the one hand, I admired the fact that he recognized the difficulty. This is not like you're going in and representing yourself for a ticket. This is murder. And I think that, Sarah would not have made a very good pro se attorney, or a very good pro se, the trial would have been a circus. I think that, so in that way, in that regard, I had respect for him for seeing her plight and reaching out. The problem that I had and have is, how can you be magnanimous enough to take time to go meet with her for hours, right? And then agree to represent her, knowing that there is a strong possibility that the judge is not going to give you this continuance that you asked for, and that you're going to have to do exactly what he's talking about right now, which is to, basically shut his practice down, right? That she's his only client, and she's not obviously his only client, but his sole focus has to be on this case. And he but he knew that going in. And I I admired that in him initially. But then he said what he said about George and about Pharrell. And I thought it was dirty pool. I thought what he did was unethical. I think to take it's one thing to use the battered spouse defense, which I'm not sure really truthfully applies in this situation, but I'm out of my depths when it comes to psychology. But to attack the victim, to blame the victim in this case in the media like that, I thought it was wrong. That's what I didn't like. That's when it started to change for me. He said it he knows, KPM said he knows mentioning his brother would never be let in, but he said it on the news for people to hear. Exactly. It was an attempt to blame the victim and make Sarah appear. He was in an attempt to humanize Sarah Boone, because what the public knows about Sarah Boone is her crime and her letters. That's what he knows. And I don't like it. I thought it was dirty pool, especially this is what it was such a dichotomy. Here he is, right, saying, I saw this situation, I saw her plight, it's like a David and Goliath scenario, because it's a murder trial. She has, she's incarcerated. It wasn't her action. Like, she didn't say outright, I, like Darrell Brooks did, I want to represent myself, right? And she's, the odds are stacked against her, and he saw it and he thought, oh my gosh, I can't believe nobody stepped up. Let me go at least and meet with her, blah, 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 right? That's on the one hand, like you're a do-gooder. But then out of the other side of your mouth, you said what you said about George and his brother, which was just wrong. I don't know. It just feels kind of, I don't know, kind of gross. I didn't like it.
Just to try to catch up and just be, which is essentially what I'm having to do now.
Well, you've seen the body cam, all the interrogation videos, the 911 call, and then of course the cell video. It starts there, right? But in terms of getting prepared in 30 days for this trial, that's 4 years old, and a lot of things have happened. Can you do it? And will you be ready?
Well, I'm gonna do my best with the time I've got left. That's all I can do. I'm gonna get some help. I've got to get some staff helping me. I've got a couple of lawyers that are buddies of mine that have offered their help. So,
how I should send
I'm
that
trying to-
lawyer from the Northeast down to help you. Joseph Krowski is the guy.
Yeah.
We'll let him know that he's the reason that you jumped in the case. He may fly down there to help you. He's up in Boston. It's
Okay.
cold. He may come
Okay.
down and help you.
And that'd be great. And I've got 2 lawyers.
Well, my advice, Mr. Owens, is since you do like watching the YouTubes, that you should watch the YouTubes in your downtime, that you should watch the YouTubers who have covered this case, right? Because I think that would give you a great handle on potentially what you're facing with the jury. Because at the end of the day, and I'm talking about the regular everyday folks on YouTube. I'm not talking about LawTube. That's a whole different situation. They're talking about this case and any other case. They're speaking, from their professional experience, their education, etc. People like this channel, Melissa Jade, ATS News, those that have covered or talked about Sarah Boone, we're everyday people. Hell, I'm a fucking Florida resident. So if I were in a different county, if I were in Orange County instead of the county that I live in, I would be part of the jury pool. Of course, obviously you would never put me, because I've covered this case, on the jury pool, or, on a jury. You wouldn't seat me. I would be out immediately, which I don't care about, but I'm the type of person that is going to be part of the jury pool. And so are these other creators. And I think that if you don't have a lot of time to prepare for this case, you got to do what you got to do. And I would advise that you listen to the people that have covered this case on YouTube, so you can get an idea about what might the jury be thinking. And I'm telling you right now, in my opinion, I couldn't even begin to offer you any type of advice that would get me to look past those videos on the cell phone. I'm sorry. There's nothing in there. There's nothing in that you could ever say to me. That I can think of right in this moment that would convince me that what I saw on those videos wasn't a depraved indifference to human life. Especially that part, that's on you.
That, like I say, I think are going to help me, are pretty much committed to it. They're friends of mine, and I trust them, and they want to help me. And they realize I thought the case was going to be continued. I respect the judge's decision, but I really, really thought.
Let me.
Back, first of all, before I read this comment that's pinned, hold the phone, back the milk truck up. What is it that made you think that the judge was going to grant you a continuance? Again, for the record, let the record reflect that Jen Liu has a good enough diploma. Okay. And even I knew, reading that order, it was pretty clear, it was pretty plain that he was not going to grant a continuance unless there were extraordinary circumstances. What about that was difficult for you with your education and your experience as an attorney? What did Judge Kraynick say? You've tried over 100 cases or something like that. You've taken a ton of cases to trial, right? You know how many cases I've taken to trial? 0. And even I knew that judge was not going to grant you a continuance. But let me read this comment from NWAW Skeptic. How about taking a similar case that isn't in the national headlines, where you won't get plastered on national news outlets if he's so truly virtuous? Boom. You're right. You're right. There are many, many, many people who are sitting in jail right now awaiting trial, some of whom might actually be innocent, who would love an attorney who came to their rescue and said, you know what? We got a little bit of time, but we got a lot of work to do. And I'm going to recruit, call in some favors, get some help on this case, but we're going to be ready for trial. And that could make all of the difference in their case. Instead, you know, whatever. That is a good point. Hold on a second. Yes, KPM, I did. KPM said, Jen Lou, did you play the first part of her interrogation video where they read her rights, where they read her rights to her? Yes, I did. All right, here we go.
Let me ask you this. Have you spoken to any of the other 8?
Yes. I spoke to Ms. Cashman, who was the last lawyer that had it. I've tried to speak to Mr. Padilla out of Miami. He's the one that had the case initially. He had it for about 2 years, maybe 2.5 years. He did most of the discovery, took most of the depositions. I think they were pretty much ready for trial or getting close, and he withdrew. But I've tried to call him a couple of times. I know he's been in a double homicide case they just got out of, but I never was able to speak with him.
And you're doing this pro bono? I don't think she has much care.
No.
Oh, no? Yes, he's changed his mind. So Harlot says, I don't think of it indifference to human life because I don't think she thought death was even an option. But I do think she was trying to punish him and didn't care how he felt or if he was in pain. Well, I don't think that she thought he would die. I think the depraved indifference comes in, for me anyway, when he's begging you to be let out and telling you that he can't breathe. And I had never heard George speak out other than in that suitcase video. But then some of the other videos from calls for service had been released, and you can hear George talk. And to me, it sounded like he was struggling to breathe. It sounded like he was having trouble, and he was begging her. And the other thing is, you know, they looked at Sarah. They photographed her. They checked her body for scratches, for bruises, and she had none. And so it isn't like there had been an altercation between the two of them, recently, within the last 2, 3, 4, where the marks would still be visible. And Sarah herself said that it was a good day. She went full Ice Cube at day camp. They did arts and crafts. There was music. There was wine. It's the video. It's the video for me. It's just absolutely the video. And I think that the jury is going to probably have the exact same reaction to that video that I did. Her Queen of Hearts, Charnel says, her reaction to the 911 operator when instructed to give CPR and she was sarcastic when she was pretending to count haunts me. Absolutely. Absolutely. And then Harlot said, they had a super toxic relationship where they were hurting each other all the time. They were probably both desensitized to it. Well, I will say that look, it's irrefutable, undeniable that George has a domestic violence charge on his record, and Sarah Boone is the victim of that. There's also undeniable charges or undeniable proof that Sarah Boone although the case was dropped, she was also charged in a domestic violence situation where was the perpetrator, George was the victim. And I do think that it is reasonable to say that they had a very toxic relationship. I'm quite interested in, even if they don't allow for the battered wife or the battered spouse defense in the trial. Let's say they're going to bring up her mental health, okay, at the trial, and certainly should she be convicted at sentencing, it will definitely be a mitigating factor. And I'm very, very, very interested in hearing the results of any tests and evaluations that any of the forensic psychologists perform on Sarah, the state and the defense. Because as you may or may not know, my bestie, Dr. B, knows all the things about forensic psychology, and she is quite adept at interpreting data from tests and evaluations and putting multiple tests and multiple evaluations together and explaining the results. And so I'm very interested in hearing what the results are. You're all right. I see in the comments that you guys are talking about the CPR situation. I think that see, when the paramedics got there, you could hear them because Sarah hadn't even hung up with 911 yet. That he had been down, there wasn't anything that they could do. They could tell by the state of his body that he'd been gone a while. He was down too long, I think is the words that the paramedics used. And I've always wondered if Sarah, why she wasn't more adamant with the 911 operator in saying, no, he is dead. He is cold. He is stiff. There is no pulse. Why did she go through the facade of pretending to do CPR? And that is one of the questions that I have. Why did she carry on that facade? And I think that's one of, how I say there's always like questions that you have going into a trial, and the majority of your questions get answered through the trial, right? The evidence, they connect all the dots, all the things, right? I really do think that that's going to be one of those questions that I probably won't get the answer to, because I've never understood why she kept that facade up, why she wasn't more adamant about it. The other thing that I have questions about is I've heard a couple of different things with respect to how George was. Was he actually out of the suitcase? Or I've heard that he was, like, the upper half of him was out of the suitcase and like the lower part of him, like he was half in, half out. And I wonder about that because just it's the facade of all of it. Like Sarah knew that George was dead. I mean, when somebody is no longer living, and it's not like he just passed away. He'd been passed away for a while. And I just don't understand Sarah's thought process there at all. Yes, Sarah did say she took him out of the suitcase, but I'm not 100% sure that she actually did. And I'm just curious about it. It's just one of those little details that it's one of those things that it doesn't necessarily mean anything one way or another. It's just one of those details of the case that I wondered about. It just feels like Sarah pretended to give him CPR because she recognized in that moment that she fucked up, that what she did was cruel, that what she did was morally wrong and also illegal, and that she was about to be in a boatload of trouble. That's what it feels like.
What are you getting?
Well, Sarah's got to pay me back one day.
Okay. Okay.
That was the agreement I had. I wanted her to understand that she needs to be self-reliant and she needs to be responsible for fees. I've got a bunch of clients that are paying me, and some of them only pay $50 a month. And but it's important to me. It's important to them, that we have an arrangement.
How important can it be? You're making this whole "it's so important to me" speech, bruh. You just filed something on behalf of Sarah that you are pro bono. This interview obviously took place. It's from 7 days ago, and the pro bono thing was filed, I think, on the 6th. Hold on a second. Hey, Michelle, good to see you, babe. No, I will say this. I don't think that it was planned either. I don't think it was planned. I have, yes, heard Brian's interviews. Yes, KPM. What was I gonna? There was another one up here. Okay. Neat Noodle said the ward case studies. Do we know if there's an alcohol level available for Sarah from when Ellie came to the house after the death? Okay. So all I know is what was on that body cam footage. Excuse me. And there is no mention of it, of them doing a breathalyzer, of them taking her to the hospital to have her blood drawn, none of that. Also, when she comes in for her interview, to me, there's no indication. It's not like she kept on, how when you get your blood drawn, there's the cotton ball and the Band-Aid. I usually take mine off pretty quickly. I'm a good clotter, but this isn't the best footage either. So I can't really tell, but there isn't any mention of it by the detectives. And there isn't any mention of the thought, like the plan for them to see if she's still, so the answer is, I don't know. I've not heard of one, but it's possible. I haven't heard of it. And I kind of almost think they might not have done it. All right, here we go.
To make payments, and that's what I told her.
Do you think?
Do
you think she needs to tell her story in the courtroom?
Well,
no, absolutely not.
Sarah's a unique individual. I don't know. In a criminal case, it's the time to tell her whole story. I think if it's necessary, she'll take the stand. We're just going to see how the case plays out. we'll make that decision when the time comes. Of course, she's got a lot to say. She's filed a lot of pleadings, a lot of letters, some
We've seen them.
ill-advised.
Trust me, we've seen.
Yeah.
So James, this is what I want to do.
Also, Vinny, if you need some dramatic readings for those letters, call me. I cannot imagine a scenario under which it would be a good idea to put Sarah Boone on the stand. Okay, so I read the state's response, and the state can't decide. The state can't tell the defense that they can't present a defense. They can't use the battered spouse defense. So what happens is he says, this is our intent. The defense says, this is our intent. We're going to use the battered spouse defense. And the state responds to that. They give their answer, and they said, hey, listen, due to these three reasons, we object to you being allowed to use the battered spouse defense. And ultimately, it will be the judge who decides whether or not Sarah can use the battered spouse syndrome defense, not the state. The state doesn't have that. Wait, what are we talking about in the? Hold on. Let me push play.
I want to stay in contact with you, and then we are legitimately going to reach out to Joseph Krowski to see if he is willing to get down there if he needs an extra hand. But also wanted to let you know that I wanted to let you go now because I know you've got some discovery. You got a couple more hours tonight. You can jump in there and as you get ready for this. But
so that's basically all that there is to that. I think, Joe Schmo, you have George's autopsy. Interesting. Of course, he was given a talk screen because all autopsies come with a talk screen. So yeah, I would be curious about. The thing that I'm the most curious about with respect to George are the other injuries. Specifically, he had some bruising that's mentioned in the information. And so I'm very, very curious about those bruises and what the medical examiner determined from those bruises, because remember, we have the neighbor who said that he heard what sounded like something heavy going down those stairs. And I think that I think we all have sort of reasoned out that the suitcase didn't start out downstairs like Sarah said, that the suitcase started out upstairs, and when George was inside of the suitcase, went down the stairs. And so I'm very interested in that. I know that in the information, it lists his cause of death as positional asphyxiation. But, Sarah did mention, and this is just an aside note, but it reminds me of another case that I'm looking into. Sarah mentioned as an aside that George had lost some teeth. And that, because it's interesting, because when the cops arrived on the scene, and she's standing out front of the apartment complex and she's talking to that female officer who's asking her what happened, the female officer does ask Sarah about any health conditions that George might have. And she's like, none that I know of, right? And then when the detectives get there and they take a statement from Sarah in their vehicle, she mentions that George was concerned, and she was concerned because he had some tooth loss. And I'm just interested about that. I'm curious if she just totes made that up, or if that is something that is true, or if he had, some other, nothing that was a contributing factor to his death. We all know what caused his death, but just I'm curious about that. Just because, she said it, and it's such an odd thing to say. It came so late. It almost seems like, that little hamster with the busted knee and the squeaky wheel, figured some stuff out. You know what I mean? And was starting to come up with some things, ways to explain some things. And let me look, Lisa, let me look really quick, because that's not what I saw. But let me just look. I'll look. I see where the state filed, but I don't see where the court answered. So let me look that up, because that's important. If I want to make sure that I have the right information. So let me look. On the 9th, you say? Okie dokie. Let's see. This is from the state. On the 9th. Okay. Hold on. And this is their answer. It's a petition or motion to strike. Let's see what this is. This is a witness list from the state. And the last thing that was filed by the state was on the 11th, which is today. Comes now the state of Florida by and through the undersigned state assistant state attorney, that basically they just sent electronically previous deposition transcripts. So I'm not seeing the court's answer. Why does something like, Harlot says, why does something like that even need to be approved? That is a question for an attorney. See, there are all kinds of somebody who's charged with a crime is under literally zero obligation to present any evidence at all. The burden is entirely on the state. The state has to prove everything. The defense has to prove nothing. So my best guess is that things like not guilty by reason of insanity, like with Letitia Stout, if you're planning to use a defense, which to me, it really does sound like a battered spouse syndrome defense is an affirmative defense. It's like you're saying that you're agreeing that you did what they are charging you with, but that you did it out of self-defense. You were in fight or flight mode. And I think that Yeah, it's memberships, babe. Neat noodle. And so I think that when that type of defense is going to be used, the state has to also have an opportunity to because the burden is on them. So the state has to have an opportunity to have their own experts in there to evaluate the defendant for a defense like that. And I think that but what from what I'm reading from the docket, and again, I must say, I'm not an attorney, but I can't see anything filed from the court. It's just the state. Because there's no order. Yeah. So this is just the state saying, hey, we don't think that she's a candidate. We don't think that she can use the battered spouse defense. But anyway, and that's what I'm waiting for, Lisa, is the state's or is the judge's response. And I'm wondering if the judge will rule on this before the 26th of September, because that's when the final trial status hearing for trial is going to occur. And it just seems to me that it's really cutting it short. Thank you, Joe. I appreciate that. Thank you so much for sending that. I got it. I just got the notification. Thank you. And thank you, KPM, for giving me a headset, babe. I appreciate that. I'm definitely going to look over that. But yeah, I'm curious about how that is going to go with this whole thing. But anyway, that's really all that I had for you guys tonight. I thank you guys all so very, very much for being here and supporting me and welcome to the new members. And it was a good conversation, I thought. But anyway, I will be back tomorrow. There's some stuff going on with the Daybells, both of them, that I want to talk about with you guys. And so I think I'm going to do that tomorrow night. So anyway, also don't forget that I every Wednesday in my Patreon, I have a series called Bedtime Books with Bindi. And it's just me reading true crime books. The book that I'm reading this time is Box Full of Nightmares. It's a book written by Vicki Edwards, but it's based on journals, notebooks that Terry Hobbs, who is the stepfather. Well, him and Pam are divorced, but anyway, he is the stepfather of Stevie Branch, one of the 3 8-year-olds who was murdered in West Memphis back in 1993. Michael Moore and Christopher Byers were his 2 friends that were murdered with him. And this is Terry's looking back on that time in 1993 and what happened subsequent to that. And this week is really interesting, the things that he had to say. He talked a lot about he and Pam's marriage and the dissolution of their marriage, and some incidents that happened. And I found it to be interesting. So anyway, I do that on Patreon every Wednesday at 9 p.m. Eastern. I make the link. I post the link So if I, you guys can have something to listen to, like falling asleep or whatever. I have it. This week's is set to rain, like a thunderstorm. So last week it was a beach. So I try to do stuff like that so you can fall asleep. I think I want to read Untying the Knot, which is the book that's told or written from like John Mark Byers' perspective, which he is the adoptive father of Christopher Byers. So I want to read that. So anyway, it's just the book is interesting, and I wasn't going to read it. I've had it for a long time, and I want to put all the things that I've done on the West Memphis 3 case together in a documentary. And there's no way for me to really do that documentary, not address Terry Hobbs in any way, at all. And I figured I'm going to have to talk about Terry. It'd be nice to hear from Terry. So that's why I decided to, my friends got me his book a couple of years ago for my birthday, and I haven't had a chance to read it. It's not that easy of a read, frankly. And so you guys letting me read it to you is really helping me. I'm actually retaining the information, which better than when I read it to myself. And now I'm off in the weeds talking about nothing important. Anyway, if you're interested in that is in my Patreon. Let me and Neat I think Neat did it. Yep, Neat's on it. Neat Noodle dropped my Patreon link. So I only have one tier. It's $5. Anyway, so that's that. I think I know Allie and I are going to do some more, are working out a schedule to go over more calls from everybody's, from Letitia Stalk. So yeah. Anywho, that's what's going on. I want to thank you guys all for being here. If you haven't done so already, give your girl a thumbs up or a thumbs down on the stream. I would appreciate it. It keeps me in the algorithm. You got to play YouTube's game. So that's really all I had for you guys. I'll see you tomorrow night. I hope you guys have a great rest of your Wednesday. And yeah, I'll talk to you guys later. Bye.
Cause it's Friday, you ain't got no job, and you ain't got shit to do. Well, fuck you.
No malicious intent or effort was towards it.
No malicious. Pity
Minutes later.
We all do a little mad sometimes. Oh.
Man!